In today's agenda, we'll be discussing on some of the important elements as well as some CIPP concepts. And then we will also look into some of introduction to the CIPP and other stuff. All right. So the first content is in terms of what is data privacy and what is the correlation with information security and how they are related and how they are different. So the term data privacy has been there for a very long time, but there is no one formal definition for data privacy. That's the actual difference or the beauty of the data privacy domain, because my privacy versus another person's privacy can completely vary. A good example is what I post on social media and what I'm comfortable with sharing my information is completely different to another person. All right. So that is the reason we do not have any common definition, or there is no standard definition what we use it for data privacy. It varies from land to land, language to language, and so if we have to give a layman's term in terms of what a data privacy is, so it is a right to be left alone or a right to have a control over your data, right? When it comes to data privacy. So as an individual, you should have control on what data you have and what data is getting shared. You need to have a control over it. So that is data privacy. And so it's very, very important that you as a data subject need to have a clarity on what is your right and how do you use it, because it's a law which provides you this right? Because your data privacy is a human right as well as a fundamental right in many countries, and that's something which is very, very important for you to know. So in India also, we are expecting the DPDP bill soon to be implemented, and so when the law is passed, then it provides you certain data subject rights, which all of us should definitely be aware and use it in the right circumstances. So that's the important part. When we start data privacy, it always starts with user awareness, right? And so when it comes to the difference between information security and data privacy, so information security is protecting an organization's data, and so the data is what drives the business, and we ensure the confidentiality, integrity, and availability when it comes to information security, right? When it comes to data privacy, we need to protect the personal data in the when we collect it, process it, and in the entire data life cycle within an organization, right? So what is the difference between these two terminologies? That fundamentally in information security, we never worry about what data we collect and how much data we collect, right? But when it comes to data privacy, these are the foundational difference between information security and data privacy. Data privacy questions every organization: why are you collecting this data, and how you're going to use this data, how long you're going to retain this data. All these questions are very much fundamental to data privacy, right? So as I said, data privacy is a human right and foundational law basis, and so you need to have this awareness to ask this to an organization who are collecting this data, right? You need to know what is the purpose for collection and how this data is going to be used, and where this data is going to be shared with someone, right? That is something which is a very key difference between information security and data privacy. And another important term is that are they interrelated? Yes, obviously. Information security is considered as one of the key enabler for data privacy and data protection, right? Because to fulfill your protection of personal data in any organization's life cycle, information security is a standard to protect the organization's information, and it has a value attached to it. Whereas data privacy is a foundational human right, and it's a foundational law, and the rights given by a particular data privacy law in that jurisdiction, and it is about empowering a data subject, right? So this is something which is very, very important. And when it comes to data privacy, we are going to ensure the protection of personal data in the entire life cycle. We are going to look into the data subject access rights, the consent, the consent, the third party vendor management, due diligence when it comes to processor, sub-processor, how you're going to maintain the data retention, data removal, your policies and procedures, how do you handle a data breach. So these are some of the specific domains when it comes to data privacy. In terms of security, you're going to look into the protection part, which is encryption, network security, access control, monitoring, and data leakage prevention and other things, right? So this is one common difference which you need to know when it comes to data privacy and information security. Moving on, the next important topic is what are the different certifications which are available for data privacy. So IAPP is the pioneer institution which actually provides the different data privacy certifications in the market. So IAPP stands for International Association of Privacy Professional. So whatever information security certifications which are in high demand in the market are provided by IAPP. Some of them include CIPP, which is Certified Information Privacy Professional, and Certified Information Privacy Manager, CIPM, and finally CIPT, Certified Information Privacy Technologist. We will closely look at each of these certifications one by one. The first certification is CIPP, and in CIPP, we are going to look into different data privacy law, and it has 4 sub-variants. The first variant is CIPPE, which is the European Data Protection Law, GDPR, and second, we have CIPP US, which is the US data privacy law. Third is Canada, and fourth is Asia. So we have 4 different variants, and what is the difference between these variants is that each of them focuses on that particular data privacy law or data privacy regulation in that particular country, right? So why should a candidate pursue CIPPE versus any other variant which we discussed right now? It's one of the very common questions many candidates ask. So CIPPE, which is the European Data Protection Law, is considered as a gold standard, right? So if you see what we see in terms of GDPR as a data privacy law is not the first law that has come up. It has an history of more than 40 years when it comes to data privacy, right? And before GDPR, we had 1995 directive, and we had many other laws in particular European data protection scenario, right? So that is the reason we need to choose a particular CIPP course which will help us to understand the law in detail, and this deep understanding which will help us to actually look into any other data privacy regulation, right? You can easily adopt to that particular regulation. For example, the law which is going to be in India, you don't need to worry if you completely understand one particular course like CIPPE. 80 to 90% of any data privacy law will have a common crux, right? And maybe 10 to 50%, 10 to 15% will vary in terms of terminologies. Instead of controller, we can call it as fiduciaries, or there will be few data subject rights which are specific to the particular law of the land, and we will see the penalties will change, the law basis will change. Very few changes will be there. Why is there a lawful basis? What are the principles? What are the different data subject rights? How do we apply them? How do you interpret a legal requirement will always remain the same. That's the reason you need to understand one law in detail. And if it's GDPR, that's the best option because that's considered as a gold standard in the industry. And second course is CIPM, which is Certified Information Privacy Manager. And this is the only course which is available for a leadership role when it comes to data privacy. Anyone who wants to elevate their career and move into the managerial role or leadership role, right? And so this course speaks about the day-to-day operations of data privacy professional, right? How do you build a data privacy program from scratch? How do you start with the vision, mission statement? How do you build the framework? How do you build a privacy strategy? How you're going to implement the policies, procedures? How do you going to look into the controls, into the personal data protection? All of them are getting covered here. right? So this is the important part of CIPM, and it's a very, very important course in combination with CIPPE, because if you want to become a data protection officer, ideally the combination is CIPPE plus CIPM. The reason is you need to know the law in detail. You need to know how to interpret the legal requirement, how to know the nuances of a law, and then how to build a data privacy program from scratch. So these two combinations are, we call it a deadly combination, and that's what is being required in the market as well. If you go into any leadership role in LinkedIn and search for a job, you will find these two courses as the most wanted or the most required combination, right? Even IAPP recognizes this. If you complete these two certifications, you are considered as a DPO ready, which is data protection officer ready, right? So this is the importance of doing these two certification together. And we have one more course, which is CIPT, which is the certified information privacy technologist, right? So any individual who wants to pursue a technology role in data privacy domain and understand how the technology aspects like embedding data privacy by design, right? And how do you manage personal data protection in the entire life cycle? What are the different encryptions available? What are the different ways to protect the data, like anonymization, pseudonymization, and we'll go into depth of all these things. What are the different threats to personal data and technology landscape? So this is all about your CIPT course. It's again a very interesting course. If someone is into the development zone, who wants to take up the career in terms of embedding data privacy solutions from a technology perspective, CIPT is the best choice for them, right? And so if you finish two out of these three certification, you will be eligible to become a FIP. Okay, FIP is Fellow of Information Privacy. It's an accreditation by IAPP. When you have 3 years of experience, and you can, if you have completed two out of these three certifications, and you have a few referrals uh, to certify your experience, then you will be joining this elite tag. And it's something which is very, very respected in the data privacy domain, and a lot of people pursue in terms of getting this coveted title, right? So this is about the different certifications. There are other courses which are available in the market, but when you're going to do one certification in data privacy, I would always recommend you to pursue CIPPE first and then go to CIPM. And that's a sequential order. The reason is CIPPE starts with the foundation of what is personal data, who is a controller, who is a processor, and then move on to a course with the higher level of data privacy management on day-to-day life, which is your CIPM course, right? So the sequence is CIPP and then move to CIPM. Then that makes you cover a holistic requirement becoming a data protection officer. So why CIPP? We did discuss. So this is considered as a global standard, and so any candidate who wants to enter into this data privacy domain, this certification demonstrate their understanding of a principle-based framework, the knowledge base in information privacy, and within the European context, right? So it's like a must certification if you want to pursue a data protection officer career, and you'll be recognized as part of an elite group of knowledgeable and capable data privacy practitioners. And as I said, the combination of CIPM and CIPP makes you DPO ready. So it's benchmark for all the hiring candidates, hiring institutions, and there is a lot to know, and there is a lot to stake, and there is a lot of opportunity for the privacy professional with the right training and education. So some people are asking in terms of the difference between other certification. I can't comment on other certification, right? The only reason we recommend IAPP is that if you go and check yourself in any hiring platform or any European Union requirement for a data protection officer or a data privacy manager, the standard requirement is always CIPP and CIPM plus CIPT if you are going to a technology road, right? So if you want to invest in the right certification, because getting certification is one part of your journey. Maintaining that is another important part, right? So if you're going to invest your money, effort, and maintaining a certification, always invest in the right option, right? And so other certifications yes, they are good, but you need to see how effective are they, how effective are them when it comes to getting an offer, right? So that is something which we need to understand. So starting in terms of what is this course about and what is the certification exam about, right? So this exam has around 90 questions when it comes to CIPPE, and out of which you need to score 75 questions, right? You have 2.5 hours to complete this, and there are no experience or educational prerequisite for taking this exam, right? So any fresher right out of the college, you can go for the certification. Even when you are, I've seen law students who join my course, even when they are pursuing their course, legal course, they tend to clear this exam, right? So there is no prerequisite for you to wait for giving or appearing for this exam, and there is no there's nothing stopping in terms of any particular previous experience, work experience, or education, or anything like that for you to start this certification course, right? And so you can take the exam either online or offline mode. Once you have purchased this exam voucher, you have 1 year of validity to give this course, right? So the next 2 points are very important. At the time of writing this course, so you have to pay $550, which is the cost of this particular certification exam value. And upon passing this exam, you must pay a fee of $250 to become officially certified. So I'll explain this. So if for any certification exam, you need to pay the cost of the exam, which is $550 in case of any variant of IAPP exam. All right. And you once you pay this for appearing this exam, once you clear the certification, you have two options. One, you can pay a $250, okay, to become a member, or you can pay a 275 sorry, you can pay $250 for validating the certification with certification maintenance fee, or you can pay $275 to become a member. So there is a difference to it. To pay certification maintenance fee, the cycle is for 2 years, and you do not get any perks what you get in terms of a membership. For example, membership, you get access to a lot of wonderful articles and useful materials, course, useful templates for in your data privacy day-to-day working, and that is available only when you become a member, right? And so this is the difference between certification maintenance fee and a membership fee. So you have both options. Either you can pursue a membership fee, which is coming at $275, and certification maintenance fee comes at $250. Now coming in terms of what we offer at InfosecTrain. So when you come to InfosecTrain, there is a clear advantage of you taking up this particular course at InfosecTrain. I'll explain that to you. So you will get the 1 year membership, IAPP official textbook, and IAPP official guide, all at less than $800 at InfosecTrain. When you look at the above option, you see you have to pay $550, and again you have to pay either $250 or $75, right? And at almost the same cost, you're gonna get a live training plus 1 year membership and the textbook and the official guide which is provided by IAPP. So just giving another example here, the IAPP textbook alone cost you $75 if you purchase separately, right? So if you add up these options, you cannot clear this exam without having some of the official materials like any other certification. You need to at least read once the textbook and at least have an understanding how IAPP frame questions, right? So that's the reason you always need to pursue the official study materials. And if you look at the total cost when you come to InfosecTrain, you see everything is included less than $800. The same cost we are going to pay more when you're going to pursue it separately, right? So at $800, less than $800 InfosecTrain, you will get all the materials plus 1 year membership, which it makes a win-win situation for you to join this certification, right? And you do not have to take the exam again at the end of 2 year cycle, or after any certain cycles which maintained by IAPP. So you simply need to earn something called CPE, which is continuous professional education, and pay the fee. You will remain certified. So you don't need to pay. You don't need to write this exam again once you have cleared. All you need to do is pay the membership fee or CMF, and also maintain your CP credits. Okay, there are very easy ways to get CP credits. So for example, this particular webinar which you're attending, you will also get CP credits for this. And if you attend the course through InfosecTrain, you will also get, I think, around 12 to 13 CP credits directly. And by reading the textbook, you will also get another 700 7 CP credits. So getting CP credits from IAPP is very, very easy, and that can be easily managed compared to other certification exams, right? So why InfosecTrain? This is what we offer compared to other market players, and what is the key differentiators. So we do provide 32 hours of instructor-led training, no recorded sessions. So it is we guarantee the lowest price you can compare in the market, an approved and certified instructor with FIP, and we have career-oriented skill-based course. So we keep adding and fine-tuning our content to relate to the current industry demands. And there is a mock exam included going forward, and part of this you will get IAPP ebook plus notes, exam voucher plus 1 year exam, 1 year IAPP membership, right? And key differentiator from other vendors, it's a practical and quality preparation with sufficient time to understand complex topics. This is a very, very important differentiator. If you go to any other market vendors who are operating and providing this course, none of them give you 32 hours. And why this is important is that uh, you need 32 hours to understand such a complex topic like CIPP and CIPM. You need to break down the concept. If we are going to study the law, right, in CIPP, you need to break it down, understand what it requires, go back, read with whatever information I'm going to provide you after the classes, and come back with a lot of questions to clarify your doubts, right? So this process will help you to just not to clear the certification, but to make you ideal data privacy candidate, right? So that's the reason this is a very, very important differentiator when you come to InfosecTrain. So this 32 hours is a definite guarantee that you will be able to not only clear the certification, but you will become a good data privacy professional by end of this course, right? And so case study approach with practical case studies provided at most of the chapters. So that's another key differentiator. You'll see a lot of case studies in the entire course. So that will be relating to your practical scenario that you may face in the office. And templates and other useful resources are always included. I'll be sharing a lot of useful resources for both the courses. And there is a dedicated exam strategy session, and exam support will be provided, and I'll be giving you my guidance in terms of what are the do's and don'ts, what are the materials that you need to practice, what you need to avoid. Those are exclusively covered part of an exam strategy session, and I do support till the time you get clear, and even after that. If you for the candidates who are cleared with me for the last 2 years, they have been connected with me. We have a separate group. I keep sharing a lot of useful information which is for their day-to-day operations, and it's quite a healthy community we are building around, right? And I do help help candidates who are just out of college, or they are trying to shift from one domain to another domain. I do help them in terms of career guidance, what you can do ideally to shift or make your career in data privacy, and what are the what you need to do in terms of building the blocks to achieve what you say a wonderful career in data privacy. And this is the best time what you can do it, right? And the reason is, when the law comes in India, you're going to see a huge demand for data privacy in India. Every hospitals, manufacturing, IT company, everyone will need a data privacy officer, data privacy manager, data privacy analyst, right? And that's going to have a big boom. In today's world, two important topics has so much significance. One is artificial intelligence and second is data privacy. You can check it yourself everywhere. These two domains are going to have a lot of importance for the next 5 to 10 years. So if you're going to invest in data privacy, this is the best time to do it. And just stay ahead of the curve by doing it before the law comes into picture. The law will give maybe 1 or 2 years for all the companies to implement. That means every company is going to hire people to implement data privacy, right? So this is the best time for all of you to invest your time and energy and effort in data privacy. So good news for all the people. Unfortunately, for the people who left after the half an hour, I'm really sorry because I don't know how many of you joined again. But whoever has joined this course, there is an exclusive offer, which is 10% off for only the webinar attendees, and it is valid on enrollments before 6th of August. And I will definitely share a contact person, Mr. Saksham, and you can reach out to him and you can check in of the different options, what you can enroll for with a standard package or training only, whatever you want. There are different options available. You can reach out to the team. And so all your queries in terms of what will be included in the course, everything will be clearly clarified. As I told you, when you opt in for the course, you'll get all the official materials. Someone raised this point about official Q&A. See, official Q&A, IAPP has now come up with 90 question bank for CIPP and CIPM and CIPT, but that is a separate material that you need to purchase, right? That's a difference because they don't provide question bank part of this curriculum. They provide all the official materials, including the textbook, and they also provide you in terms of a study guide, right? That we will be discussing on all the classes. So another good news is that we are launching the Certified Data Protection Officer course. And so this course is going to be a very highly effective course for someone to become hands-on on data privacy. And we're going to cover these agenda items. If you see the agenda items, it's all the day-to-day operations any data privacy professional is going to work. So building the data privacy policy, procedure, strategy, and framework, doing a data discovery, ROPA, and retention manually, data privacy by design and security of processing. What are the different assessments like a DPIA, PIA, and there is an error actually. So, and along with that, you also have your legitimate impact assessment. Okay, third-party assessment, and these are the different assessments we will be covering part of this course. And we also have data subject rights. Do we still need TIA? Yes, TIA is a very important requirement. TIA will be required whenever we need to do any international data transfer. See, we also have the current US EU transatlantic framework, but it's not sure when it will be struck down by the next case, which can come in max crime. So TIA is very much correlated. Data subject rights management, data breach management, data transfers, TIA, CBCR, which is standard contractual clauses and binding corporate rules. TIA stands for impact assessment. And finally, cookie notice and consent. Right. So we are going to cover all these domains, part of the CDPO. You will have an exam which you need to clear. The duration of this course will be 24 hours. And there is a prerequisite for you to appear this exam because we are not going to go theoretical completely in the session. So we expect you to have CIPP, CIPM, or a foundation training, right? So we're going to launch a foundation training somewhere later. So if you have existing certifications, or you need to have a clear understanding of your CIPP, right? And that will be helpful for you to appear for this particular course. So once you clear this exam, you will have this title of Certified Data Protection Officer provided by InfosecTrain. All right. So we do offer combo courses in terms of CIPP plus CDPO, CIPM plus CDPO. So these combos are extremely useful for you to make yourself ready for the data protection officer role, which is going to have a high demand going forward. And we also provide multiple data privacy consultation services at InfosecTrain. If you're an organization looking for starting your data privacy program, you want to do a gap assessment, you want to build your data inventory, you want to launch the data privacy program management, do a cookie assessment, you want to do multiple assessments, data processing agreements, vendor management, and benchmarking study, we are all there. So if you need any help, you can definitely contact us. We'll be more than happy to support you on the consultation requirement. All right, so that is all about introduction and what we needed to speak in terms of the general topics. So today we are going to start the first two chapters. I'll check the time, and if you're not able to cover the second chapter, we will focus it for the tomorrow's session. So today's topic, we are going to look into the foundational elements of data privacy in CIPP course, which is your personal data, sensitive personal data, what is pseudonymous data, anonymous data, processing, processors, controllers, subprocessor. So we're going to look at all these topics. For this particular chapter, you're going to expect minimum of 3 questions and maximum of 6 questions. All right. So what is personal data? The GDPR defines personal data as any information which are related to an identified or identifiable natural person. And this definition may look so harmless that it's quite easy to understand, isn't it? But each of these keywords have a lot of inference, right? When I say any information, what categories can fall into any information? Does it cover paper assets? Does it cover opinions? Does it cover technological data like cookies? So what constitutes any information? So we will see a lot of examples when it comes to what are the different uh, types of personal data in which can constitute into the GDPR material scope. Right. Let me give you an example. What do you think an HR in a HR appraisal system in your company, right? So generally, your managers, your the lead HR will give certain opinions about you in terms of your performance in the company, right? And do you think those opinions are bound by GDPR if you're operating in GDPR, European Union region? So for just to keep it simple, I'll not relate everything into European Union region. So whenever I give a scenario, you need to think this is from that particular territory. All right. So in this case, the answer is yes. Opinions generally fall into the GDPR definition because it is definitely related to identified or identifiable natural person. So that is a very, very important difference which you need to know. And also, not only opinions, even paper assets can become a part of your GDPR scope, but not all the paper assets. That's a clear, important point from the exam perspective you need to know. Paper assets, which are part of filing system, right? When I say filing system, what it means. So if I use a paper asset for a KYC form, right, which is part of your when you become a bank's customer, the first document, an important element, which is your KYC document, you need to fill all your personal data, and that particular document becomes part of a filing system, right? Similarly, if you go pay your income tax or any important passport application, this paper assets can become your GDPR scope. Okay, so reason is these documents are clearly classified, and these documents are protected by your organization, right? So that is a clear demarcation when it comes to GDPR, that we protect, we consider paper assets only which is part of a filing system will come into the GDPR material scope, right? And technological data, your example cookies, your IP addresses. Generally, people think IP addresses are not personal data because it can change from when we're using a dynamic IP. You tend to believe that dynamic IP may not fall within the GDPR scope, right? So when it comes to personal data processing, the context is very, very important, right? So cookies are definitely personal data because they contain a lot of information about a person, and even IP addresses in the hands of ISP, which is internet service provider, right? So that particular context will make this dynamic IP will also fall under the GDPR material scope. All right. So the next important keyword here is related to a person, right? If the GDPR is not related to a living person, then it is not falling under the material scope, right? Example, there could be tons and tons of data within an organization, like your organizational data, right? So those company information, example, your company's profit and loss, there are so many confidential information within your organization, right? It is not about a person. So GDPR scope is always about a person, right? If it is not related to a natural person, then GDPR does not apply to that particular processing activity. And the last important qualifier is identified or identifiable natural person. It's a very, very important qualifier. So generally, there are types of data which is directly identifiable. We use the terminology called PII, which is personally identifiable information, right? And there are certain attributes which are not so directly identified. Example of both categories: if your Aadhaar card number, your passport, your driving license, your email ID, all these things are unique to one person, right? And you can directly zero down a person with PII. But whereas when you come to other qualifiers, like your blood group, your age, right, your date of birth, all these attributes on a standalone basis cannot identify a person, right? So we call them as quasi identifiers. And the important part which you need to know when it comes to quasi identifiers is that these quasi identifiers, when you bring them together, they can become a PII, right? You can take a common name in India, and if you go to a particular government office, let's take Amit. You go to Amit, you want to check Mr. Amit in a particular government office. You go and ask his presence in the office by asking the peon or receptionist. He will say there are at least 10 Amit in the office, right? And that shows that Amit as a name sometimes is not identifiable directly, whereas certain names can be identified. For example, Elon Musk named his son with a unique name, right? I don't know how many people in the world will have such unique name, isn't it? So that name can become a directly identifiable personal information. So the context of processing is very, very important, and you need to look at these quasi identifiers. When they are combined, they become a PII, right? So you need to pay attention when you are processing as well as collecting this personal information and how they are grouped and they are stored together, right? The last part is the keyword is natural person, right? So natural person means a living person. So GDPR is applicable only to the personal data of a living person. So that's a clear differentiated with many of the data privacy laws in the world, because in certain, like, let me give an example. In Saudi, the data, the case of PDPL is applicable to both a person who is living as well as a person who is no more, right? So, but in GDPR, the law is applicable only to a natural person who is a living person, right? So that's a very, very important differentiator which you need to know when it comes to GDPR. I've given a lot of examples when it comes to personal data, and there is one more category which is called sensitive personal data or special categories data. So special categories data include information about your racial, ethnic origin, your health data, and your religious or philosophical belief, your trade union membership, your political opinion. All these things comes under special category data or sensitive personal data. Why do we use this terminology sensitive personal data? Because when this data or this information gets leaked, it has a high significant impact on the individuals. It can lead a person being discriminated based on these type of information. Example, based on my political opinion, I might get discriminated in my office or by my peers, or it can even affect in my company's appraisal system, or so and so forth. And your health data can lead to a personal attack on that person. It can cause a grave situation for that individual, right? So likewise, all these information, when it's getting leaked or it's been disclosed unauthorizedly, this will have a high impact on the individual. That is why it is being termed as your sensitive personal data or special category data, and not personal data, as I gave you an example, where it is purely a organizational data. It is not related to a person, right? So it's a very, very important category which you need to know what is not under the scope of GDPR. Moving to the other terminologies which are important as a foundation element, which is data subject. So a person like you and me will be called as a data subject whose personal data is getting processed by the company, right? And data controller or the organization or the entities which collect the personal data. And what is the difference between a controller and a processor? Controller is the entity which actually decides why the data is getting collected and how the data is going to be processed, right? So any entity which answers these two important questions, then they will be falling under the obligation of a controller, right? So a controller is the important accountable organization to data privacy, to the authorities in terms of the entire personal data processing. They are accountable to the authorities. They are accountable to the data subject as well, because they are the one collecting it from the data subject directly, right? And they are the one who will be accountable to answer if something goes wrong to the personal data processing, right? And example of data controller, like any entity which your banks, your insurance company, everywhere where your personal data is collected for any specific reason, they are all your data controller. Who is data processor? Data processor is an entity which actually process personal information on a specific instruction of a data controller. So processor are nothing but your a sort of company which works behalf of a controller, right? So they don't take decisions in terms of what data to collect, why are we collecting it, how long to retain it. All these important questions are never decided by the data processor. Okay, best example, you have a cloud service provider. Most of us use different cloud services provider. So the organization saving data on a cloud, the cloud service provider become a data processor. Their only role is to save the data in the cloud platform. They work on the instruction like how long to keep the data. They create an interface for exchanging this information, right? So this is an example of data processor. Many IT companies who provide infrastructure support, technical support to many clients abroad in UK or in European Union or in the US, all these companies like HCL, TCS, IBMs, all these companies will fall under the category of processor for that specific context, right? So this is a difference between a processor and a data controller. If you see this particular flow diagram which is there, the data subject is the starting point of in terms of wherever this entire process starts. The data is collected from the data subject, or there is a chance even the data getting collected from a third party resource. I will shortly discuss that scenario later. And the information is then moved on to the controller, right? And the controller decides on the ways and means of processing, and it being given to a processor, right? So this is an example of a particular SoundCloud, and where the interface is decided by the controller, and there is a processor which is Google, and there is one important stakeholder here, which is a supervisory authority. Okay, so supervisory authority are the pillars of protecting the data GDPR in European Union. So they have multiple powers vested in them through the GDPR law, right? So they have powers in terms of questioning the controller, investigating, providing consultation, even slapping penalties whenever there is a mismanagement of data privacy principles and laws, right? And so this is the relationship between your different stakeholders, right? Now, these are the different obligations when it comes to controllers and processor, right? So this is a very, very important slide in terms of exam and exam questions. So if you have a clear clarity in this will help you in a long way when you are implementing a data privacy program in your organization, right? So as I said, controller is an entity which will define the purpose and means of processing, and they decide on the retention and disclosure. Disclosure is sharing of information. And the second important obligation is they comply with GDPR and demonstrate compliance. Very, very important point. There is something called accountability requirements. We will soon discuss in the upcoming chapter. And accountability needs to be demonstrated by both controller and processor. It has a high weightage when it comes to a controller. So there are important notification requirements when it comes to a data privacy breach. And these breach notification are very, very important and sensitive component, right? So every organization need to have a dedicated process when it comes to breach notification. There are a lot of scenarios we will discuss in the upcoming sessions. What constitutes a breach, when we will notify a data subject, when we will notify a supervisory authority, and we will have practical case studies to look at it, right? And then the next is conducting data protection impact assessment. And so data protection impact assessment, difference between PIA, DPIA, what needs to be documented part of DPIA. We have dedicated slides and contents in the upcoming sessions. ROPA, records of processing activity, is the inventory of personal data. Like we have our any organization will have asset inventory, right? Similarly, when it comes to personal data, we have something called records of processing activity. It's a dynamic moving inventory that gives a clear flow of how the personal data is managed by any organization, right? And the next is data protection officer. It's a very important designation which needs to be appointed when you meet certain specific criteria, right? There is a myth when it comes to GDPR that every organization needs to appoint a DPO. It's a wrong statement. Not every organization needs to appoint a DPO. If you fall in certain specific trigger, we will discuss those triggers. Then only you need to appoint a DPO, right? And what are the qualities of a DPO? What are the requirements mentioned by the law? We will discuss them in later. And what are the technical and organizational measures? We call them as TOM. Technical organizational measures are the security and process related controls which you need to implement to protect the personal data during its life cycle. And finally, cooperate with the data protection authorities. So these are the main obligations. And comes to the processor obligations, we have similar obligation. I will just focus on certain specific ones which are pertaining to the processor. You need to start working only if you have a specific data processing agreement and you have signed an NDA. So data processing agreement is your documented instruction. Without a documented instruction, you should never enter into any processing activity because it can be misused as a breach scenario, right? So without an instruction, without a documented written instruction, never indulge in any processing activity as a processor. Notify the controller on a data breach scenario. Never notify anyone else. Don't reach out to the data subject. Don't reach out to the authority. You need to always reach back to the controller. Very, very important exam question. And the final one is prior approval and contracting of a subcontractor. So if you're going to hire a subcontractor, you need to take a written permission from the controller. Without taking a written permission, never indulge in any sub-processor. Okay, so that's a very, very important that you cannot do it without the permission of the controller. All right. So we're going to look into some of the case studies when it comes to joint controllership. So what is joint controllership? We discussed about controller processor. There is one more terminology which is called as joint controller. So when there are two controllers who jointly determine the purpose and means of processing, they shall be joint controller. This is the definition of joint controller. Very, very interesting scenario. So if you read this particular case, okay, a travel agency sends personal data of its customer to an airline. So the answer is, in this case, the travel agencies, the airline, and the hotel are three different data controllers processing the data for their own and separate purposes, and there is no joint controllership. Okay, so the very important question here is, so these are tricky scenarios. When you look at the outset, you believe that all the three stakeholders are in joint controllership. The answer is no. The reason is, if they enter joint controllership, they need to decide it together in terms of the purpose and means of processing, right? Then only it's called a valid joint controllership. I'll give you other scenario. Just read the second one. Then you'll be able to understand the joint controllership better. So the answer for this is A and B are considered as joint controller for the specific processing activity related to the promotional event because they decided together on the jointly defined purpose and essential means of processing. So this is a clear case of joint controllership, right? So you will be getting such exam questions in CIPP exam. So you need to pay a lot of attention in reading every single word of the question, right? So just see this particular scenario. So if you see, there are specific laws in every country, right? The company needs to send the data to the concerning salaries to the tax authorities, right? Which reinforce fiscal controls. So what do you think in this case? For example, we have GST and we have income tax department, right? So do you think the company and the income tax department or the other government bodies which collects the information are joint controllership? The answer is in this case, even though the company and the tax authorities process the same concerning salaries, the lack of jointly determined purposes, right? And that is the reason because they are actually forced to share this data by a legal requirement, right? And that is a clear differentiator to this particular processing activity. In this case, they are two separate data controllers, right? So there is no joint controllership when it comes to this particular activity. The final example, if you go to any insurance company and there is an insurance company and there is a data aggregator like Policy Bazaar, right? And there is a hospital group. Let's take a famous hospital group like Max or any other hospital group, right? Say they decide jointly in setting up a internet-based common platform, right? For the purpose of providing a health insurance package. So there is a common package which the hospital group, the Policy Bazaar group, as well as an insurance company, right? They all come together in creating this platform to provide a meaningful or very beneficial health insurance package deals. They agree on the essential needs to be used, such as which data will be stored, how long the insurance cover will be allocated, and confirm and who can have access to the information stored. Further, they decide to share the data of their customers in order to carry out joint marketing activities, right? So if you see this particular case, the three entities are together deciding the ways and means of processing as well as they are deciding the purpose, right? So this is a clear case of joint controllership, and this however, each of them would still remain sole control with regard to other processing activity outside the internet-based platform. It's a very, very important point. So only when it comes to this internet-based platform processing activity, they are joint controller. What about the hospital? Hospital also does tons of other processing activities, right? So for those activities, they are the controller, right? So you need to differentiate the controllership and processor obligation based on each and every particular context. And you cannot have a blanket role like I'll be controller for all the processing activity which I do in an organization. That can be definitely wrong. You need to look at each and every processing activity, then decide what role you play in that particular processing activity. All right. I hope these case studies helps you to understand joint controllership, which is a very, very important tested concept when it comes to CIPP. The next important topic is territorial and material scope, a very, very interesting as well as a foundational topic when it comes to CIPP course. So this particular topic has a minimum of 2 questions and maximum 4 questions. And it's one of the tricky questions because if you don't understand territorial scope, you're going to apply GDPR in many unwanted scenarios as well as you might miss out when GDPR was actually applicable, right? We will see that. So territorial scope has three important steps which you need to have it in your subconscious mind when it comes to the exam, right? So I'll be explaining each of these terms one by one and ensure that you understand each of these terms clearly, right? If you have any questions, I will allow you to ask me. I will be able to explain them. I'm happy to stretch the session to explain this topic because it's a very, very important topic when it comes to data privacy foundation, right? To For GDPR to apply to any processing activity, it has to follow the steps which are mentioned here. First criteria is that you have to process personal data. If you do not process personal data, then GDPR is not applicable. That is what we call as material scope. Now, the second important criteria is that if a company is established in European Union, then GDPR by default is applicable to that particular entity. What does it mean? We call something as law of the land, right? In India, we have something like Companies Act. Similarly, every country have its own law, right? Legal framework. So to register a company, you need to follow that particular law of the land. Similarly, in European Union, if you are an entity established within the European Union, then GDPR is applicable to you by default, because GDPR is a law of the land. GDPR is applicable to each and every member state in the European Union. We have 27 member states. GDPR is applicable to each and every member state available there. You do not have an option, right? So that is called Article 3.1, which means if you are established in EU, then GDPR is applicable. So when I say the word establishment, there are a lot of subtext, or there are a lot of nuances to the word establishment, right? Establishment means not only officially registering yourself as an entity. Even without that, you can be considered as an establishment. If you have technical resource, you have physical resource, then still you will be considered as an establishment. So when it comes to GDPR, you need to look at two important documents when you want to look at the practical applicability of it. Okay, the first is EDPB guidelines, okay, that helps you to understand how do you need to interpret the GDPR law. The second is you need to know some of the famous judgments that came in the by the Court of Justice of European Union. Why it is important? They actually set some foundation, right? So any court case law which gives you like a foundation that can be interpreted for any ambiguous inference of the GDPR law. So that is where one such case where clearly what constitutes an establishment was clarified by the court, right? So I will discuss all these elements in detail when you join our official session. What is the case and what is the law what is the special criteria that constitutes what is an establishment, right? And the second is, if you are going to do the second criteria, which is Article 3.2a, is for any entity, even though they are not established in the EU, okay, if you are doing intentional processing of personal data, very important word, intentional processing of personal data of data subjects who happen to be in the EU relating to offering goods or services. Okay, so let me break it down 3.2a and 3.2b separately. First is, I am an entity. I am not based out of EU. Example, I have an entity in India, and that Indian entity is definitely not bound by the European Union law, right? That's quite simple. But part of my goods and services, right? If I target a particular individual who happens to be in EU, GDPR is applicable to my entity. Very surprising, right? Even though I don't belong to European Union, I am not a European Union citizen, GDPR is applicable to an Indian company which is doing a targeted business for relating to a European Union natural person or a data subject, right? It's a very, very important scenario. Like, you need to understand that GDPR has a extraterritorial scope. What do you mean by extraterritorial scope? GDPR can apply beyond the boundaries of European Union. It can apply to an entity in US, Africa, Australia, any country, right? So if you happen to be an entity operating by giving goods and services, okay, the key word here is intentional processing, right? And the next criteria, which is intentional monitoring behavior in the European Union. Don't worry, I will give you a lot of case scenarios in the upcoming slides to make you understand each of these specific criteria clearly, right? So the second criteria, which is 3.2a and 3.2b, is very, very simple. You don't need to be established in the EU, but still GDPR can be applicable to you if you do a intentional targeted process. Targeted of service or goods to a European Union data subject, and the subject happens to be in the EU, or if you are monitoring the behavior. What do you mean by monitoring behavior? For example, if I drop cookies of a European Union data subject, right, and I track their behavior, I try to understand their buying patterns. I try to understand what is their interest upon, right? This is an example of your monitoring behavior, right? Monitoring behavior happens in many ways, right? So this is one classical example of cookies trying to understand a behavior pattern of a data subject. Why do we use monitoring behavior? Because we need to do targeted advertisement, right? So as a company, there is a huge market for targeted advertisement, right? There is an ad tech industry which is working upon doing this targeted advertisement to, for example, I go and search Adidas shoes today, right? And Adidas shoes keeps following me each and every website which I go, right? Because there is a system, there is a process created behind this, right? And so all these nuances we will be discussing in CIPP in detail. And the final criteria is that if you are not an establishment and you're not providing goods and services, or you're not monitoring the behavior, but still you happen to be in a place where a member state law applies by virtue of public international law. Okay, it looks like a complicated statement, right? Let me break it down. Very, very simple, right? If you are working in an embassy, okay, and if you are in a cruise ship which is on international waters, or if you are the lucky one who is flying to the international space station, right? So in these zones, generally a country's law is not applicable. For a European Union embassy or a particular country, let's take France, Germany, their embassy, which is in India, Indian law will not be applicable to the embassies. Okay, and for the data processing, let's take the German embassy is trying to recruit some local people to do some operational activities. When they do this activity, GDPR is applicable to them, even though they are not in the European Union, they are not providing goods and services, but they are bound by the virtue of public international law, right? So this is an example. Whenever you're traveling in a cruise ship, the cruise ship is in international waters and they are processing your personal data, then and the cruise ship has to belong to one of the member states. That's an important criteria, right? And then GDPR is applicable to that particular company. So this is the three important and interesting scenarios, and I'll be discussing them in much detail when you come to the course. And you need to see multiple scenarios to understand. But at the outset, you may think like, okay, this is all about territorial scope. But at least if you don't see 10 to 15 examples, you will not be able to understand this in a complete clarity, right? So this is the reason after the session, not in this session, during my training program, I generally share a ADPP guideline, which will have a lot of examples for you to clearly understand what you need to get this territorial scope completely clear. And because it will have a lot of significance, right? If you don't apply territorial scope correctly, you are going to have a big problem in GDPR applicability, right? So this is the summary of what we discussed in a table format. This is Article 3.1, 3.2a, 3.2b, and 3.3. So this is in short summarizing, like if you are a EU establishment and you are processing personal data of a natural person, and it should be about a person within the EU or outside the EU, then, sorry, this is for EU establishment. If you are an establishment, by default, GDPR is applicable. If you are not an establishment, you are processing personal data belonging to a natural person, and by offering goods and services, GDPR is applicable. The same goes to monitoring, and finally, when you are applicable by the virtue of member state law in by your international laws, right? So this is an example of your territorial scope case scenarios. I'll be sharing you some of the case studies. You can just look at it. So these case studies are really interesting. I want you to think and answer in the chat box. We can look at them one by one. A French company has developed a car sharing application exclusively addressed to customers in India, Sri Lanka, and Nepal, right? And the service is only available in those three countries, but all personal data processing activities are carried out by the data controller in France. Okay. So what do you guys think? It's a French company. France is within the 27 member states. It is developing a car sharing application, but it is not targeting any European Union data subject. It is exclusively for the Asian subcontinent, which is India, Sri Lanka, and Nepal, right? And so the processing, everything happens in France. So the answer is GDPR is applicable. The reason, because of, remember the three-step method. The first step is, if you are an establishment, then GDPR is applicable to you default, right? So in this case, the answer is yes. By Article 3.1, GDPR is applicable by the virtue of you are an establishment in the European Union. Okay. Although the information that you collect is of non-EU countries and non-EU data subjects, but because you are an establishment in the EU, then GDPR is applicable to you. Let's go to the next case study. Mexican retail company enters into contract with a processor, right? It's a Mexican company. It is hiring a processor who is established in Spain, which is part of the EU, for processing personal data related to Mexican exclusive to the Mexican market, right? And its processing concerns exclusively data subjects located outside the European Union. I'll just break it. Just consider a Mexican company, okay? It only serves the Mexican market, okay? And it has a processor which is based out of Spain. And the processor is used to process whatever instruction the Mexican company is giving, right? So in this case, the data subjects are not European Union, and the targeted processing activity doesn't cover the European Union data subjects. So who is bound by GDPR? The controller processor. Who is bound by? You need to know that processor is working on the instruction of the controller. And the controller, if you think, is not bound by GDPR, do you think the processor will be bound? The processor is not the one who initiated this activity, right? But the controller is the one who initiated, and the controller, if you think, is not bound by GDPR, which Article 3.123 we discussed right now, then how does it work? I'll explain to you. Answer is, the retail company is not established in the EU and does not target in terms of providing goods and services. So all the Article 3.1, 3.2a, 3.2b doesn't fit in this case, right? But the Spanish company will be subjected to GDPR because it is an establishment under your in the European Union territory. Very, very simple. So the interesting case here is the controller is not bound by GDPR, but the Spanish company will need to fulfill its obligation as a processor. If you remember the previous slide, we had specific instruction when it comes to processor, right? So those processor obligation needs to be fulfilled because the Spanish company is bounded by the establishment requirement of territorial scope. Let's go to the third example. An Australian company offers mobile news and video content service based on user preference and interest. User can receive daily or weekly updates. The service is offered exclusive to users located in Australia. An Australian subscriber of the service travels to Germany on holiday and continues using the service. Okay. So it's a hypothetical scenario for an Australian-based company. It's exclusively providing mobile news, video content service, and everything for Australian citizens, right? And suddenly, this Australian person is traveling on his holiday program, and in this case, he happened to open that application in the European Union. In that particular transaction, if you see, the personal data of that Australian citizen is getting processed by the Australian company. What happens in this case? It actually somehow fits into the Article 3.2a, correct? But what you need to look at is, although the Australian subscriber will be using the service while in the EU, the service is not targeting the individuals in the union. That's a very, very important point. I told you the key word is intentional processing. Here, the Australian company is not intentionally targeting a European Union data subject, right? I'll give you further case studies to understand what you mean by intentional targeting, right? So in this case, the target is not a European Union data subject, and it is the Australian company is just providing the service through a contract for which the Australian citizen has opted for, and he happens to be traveling. So that in this case, GDPR is not applicable to the Australian company. Okay. A website based and managed in India offers services for creation, editing, printing, and shipping of personalized photo albums. Okay, the website is available in English, French, Dutch, and German, and payments can be made in euros. Very interesting scenario. This is an Indian-based company. They offer services for the creation of printing, and they also ship personalized photo albums to the European Union data subject. So, what do you think? In this case, GDPR is applicable? Great. A lot of people are getting it right. I'm happy about it. So the answer is yes. It's a intentional targeting. How do we say it intentional targeting? It should not be guess. We have to say it clearly by what it means of intentional targeting. Okay, this is the nuances I'll be discussing in my course. What constitutes an intentional targeting, right? So if you set up a website which is having languages of the European Union, yes, of course, English is a very common language. If you have a language like French or Dutch or German, which means you're trying to target a European Union data subject. And also you're trying to have payments specifically targeting European Union data subject, which is made through euros, which means your website, there is a clear intention to focus on European market, right? So this makes you fall under the Article 32A of territorial scope. So you're targeting here European Union data subject, which means GDPR is applicable. All right. I hope this scenario was interesting. The next one is a US company has developed health and lifestyle app, allowing users to record with the US company their personal indicators like sleep time, weight, blood pressure. Like you just imagine your smartwatch sort of thing, right? The app then provides a user with daily advice on food, sports recommendations. The processing is carried out by a US data controller. The app is made available to and is used by individuals in the union. What do you think? It's a US based smartwatch company, right? It monitors a lot of parameters, right? And the app also provides you food and sports recommendations. The processing is done purely by a US data controller. The app is also available through Play Store or through its website to individuals in the union. Do you think? Yes, of course, the European Union, whoever the data subjects, who is France, Germany, or Italy, who's trying to use the smartwatch or trying to be part of this particular service, their information is going to be processed by that US company. Correct? What will happen in this case? Let's see the answer. So it is to the extent the US company is monitoring the behavior of the individuals in operating the health and lifestyle app, it will be targeting in the individuals. It's a very tricky scenario. At the outset, it looks like it's just a plain service. It is not doing a target, but it comes under the monitoring part. When you are monitoring blood pressure, weight, and heartbeat, you will fall under Article 32B, right? And it's processing the personal data of the individuals in the EU. It will fall under the scope of GDPR. Very, very important, right? So it is, you are trying to monitor the behavior of a person in the European Union and the data subject happens to be in the EU, then GDPR is applicable by the virtue of Article 32B. All right. I hope everyone understood the nuance of this particular case, right? So it is applicable by the virtue of a company monitoring the behavior of a data subject, and the data subject happens to be in the European Union when this processing activity happened. All right. So the last example, a German cruise ship traveling in international water is processing the data of the guest on board for the purpose of tailoring the in-cruise entertainment offer. And I think I already gave this answer, right? Because it is bound by the requirement of international waters. The virtue of member state law will be applicable through the virtue of international laws. So GDPR is applicable to this particular German cruise ship, right? And the final case is a Dutch consulate in Kingston, Jamaica opens an online application process for the recruitment of local staff in order to support its administration. Even in this case, GDPR will be applicable by the virtue of Article 3.3, right?